Right. Good morning, everyone, and thank you for joining us this morning as we hear from Hylant. And Lisa Lavelle is the risk advisor with executive risk at Hylant, and she is going to discuss employment practices liability, which is a very relevant and important topic right now amongst business owners with everything going on. She will go through her presentation and then we will have questions at the end. So if you have any questions, please utilize the chat feature at the bottom of the screen and we will keep track of those and gather them as we go. If you could please mute your microphones and turn off your video, that will help preserve bandwidth for the presentation. And before we get started, I would like to thank our sponsors. We have Hylant, Fifth Third, Eastman and Smith, Shoemaker, Loop and Kendrick, Huntington Bank, William Vaughn, Raymond, and Skylight Financial. So yes, please just keep the questions coming through the chat throughout the presentation. And now I'm going to hand it over to Lisa.
Okay, thanks, Emily. Can everyone hear me? Well, I guess, right. Can you hear me, Emily? Because
I can.
Okay, just making sure. Well, thank you for having me today. I hope everybody's getting along in these crazy times that we're in right now. It's my pleasure to speak to your group today on a topic near and dear to my heart: employment practices liability insurance. Just a little bit about my background. I've been in the insurance industry for over 30 years, and all I do is what we call management liability or executive risk. And basically it's a specialty that encompasses a range of coverages related to the decisions that you make as business owners and executives that cause you financial liability. So it's different than your property damage or your auto coverages, so I know absolutely nothing about those. But I think it's an ever-evolving coverage, and in this world that we live in, there's a lot of complexities to having employees and the employment relationship, and you can get tripped up easily. So we're going to talk about that today. So I'm going to start with just an overview. Some of you may be very familiar with what your policy does and doesn't do, and some of you it might be a little bit of a starting point, but I'm going to give you a crash course in things like occurrence versus claims made and why that's important, and the fact that these policies are not all standardized. Everybody is different, and so there's a lot of potential nuances that could trip people up, and I'll try to point out those things that will make you just basically get more value out of your coverage. Hopefully you never have to use it. So there's two main coverage parts to most EPL policies. We have your traditional employment practices liability, which covers your organization, your management team, your executives, even your employees. And the coverages, and I have it in quotes, wrongful acts. And we're going to talk more about what wrongful acts actually are in the context of the policy. The second part of most employment practices policies is what we call third-party liability. And sometimes you have to actually request this coverage. I would recommend it for anybody who interacts as part of your business with customers or clients or vendors. Third-party liability provides the coverage for discrimination and harassment of just what it says, third parties, non-employees. So employment practices, the basic employee relationship also includes applicants for employment, so that if somebody says they're discriminated against as an applicant, or that their interview process was not in compliance with questions that were supposed to be asked, et cetera, that's still employment practices. But third-party liability is anybody without the employer relationship. And one of the more unique third-party liabilities that I've seen recently in the last couple of years, and it's something you don't hardly even think of. But if any of you want to Google the Domino's Pizza litigation about a blind person suing them because their online website was not compatible with his visual computer system that would speak to him. So he basically sued Domino's Pizza for a breach of Americans with Disabilities Act because their website was inaccessible, even though he still could call and order a pizza. And this litigation went on, and I think it went to the Supreme Court in Washington or somewhere, and literally Domino's, I think the latest is after appeal that they lost the case. And so this third-party liability kind of situation spawned a lot of, like a cottage industry on plaintiff's attorneys. And so then they go out now and they look at people's websites and see if they're compatible with ADA. So depending on how much you rely on your website for your commerce, that's just another pitfall that's out there, is these creative attorneys finding reasons to file claims. And the claims don't have to have merit. They can be totally bogus, but the defense costs can kill you anyway. And that's where these policies really, I think the rubber meets the road. So ask for third-party liability coverage, or ask your broker or your agent to confirm that you do have that, because sometimes it's not automatic. As I said, there's no standardization of an employment practice liability policy. These can be small endorsements in a business owner's package policy or your GL coverage, or they can be a standalone policy, 30 pages long. Typically, the standalone policies are usually broader in coverage, and you can get higher limits, and as you would think, they're more expensive than your $500,000 that you would get in a BOP policy. Some things that I want to point out that are different than what you would get in your traditional general liability coverage is the defense costs of these types of policies are almost always included in the limit of liability. And what we just said is the claim could be groundless, but the defense costs will eat up that limit. And so you need to be aware that it's not like your GL policy where you have your liability limit and your defense costs are outside. That's something that a lot of people are, when they're choosing a limit of liability, are not aware of. And then one of the biggest things is coverage is almost always written on a claims made basis. And this is going to be the crash course in Insurance 101. You're probably going to want to stick a pencil in your eye when I'm done talking about occurrence versus claims made, but it's very important to these types of policies. What is claims made? Well, the GL policy that we've talked about it's simple. The policy that's in effect at the time the incident occurs, so somebody slips and falls on your premises, that's the policy that responds. Even if you don't hear from that person for another year, but then you get the medical bills or the lawsuit or whatever. The policy responds will go back to when it happened. But claims made, where most employment practices liabilities are written, the policy that is in effect when the claim is received, not necessarily when the wrongful act occurred, that's the policy that responds. And you say, so what's the difference? This is the occurrence example. You see the policy period goes from January 1, 2020 to December 31st, 2020. Visitors slip and fall. Then you get the claim in the 2021 policy period. The policy goes, the claim is reported back to the old policy, and the terms, conditions, and limits of that policy will respond. So there's no real issues there. In a claims made example, we call it a wrongful act. So let's say the discrimination occurred in the 2020 policy period, or the wrongful termination occurred. And you renew your policy or you don't even have coverage, but the policy period lapses and you have a new policy, this is the policy that will respond once the claim comes in. So you didn't hear anything, the termination occurred in 2020, but you didn't get a lawsuit until 2021. So that 2021 policy responds. Well, it depends. Did you have coverage before? Do you have coverage now? And we'll talk about continuity of coverage, what happens if you didn't have coverage in 2020, but you do in 2021. Lots of considerations. And I'm going pretty fast, but as Emily said, if you have questions, send them in and we will slow down and answer those questions at the end. So if you have a retroactive date, which is otherwise known as a prior acts exclusion, there would be no coverage when you get the claim coming in here. No coverage when in 2021 if there's a retro date on your policy. If you don't have a retro date, the coverage could still respond or should respond unless there's some smoking gun back here that tells the insurance company that you knew you were going to get a claim and you didn't disclose it. So why is that important? If the policy contains a retroactive date, that means nothing that you did prior to that date would be covered, whether you knew about it being a potential claim or not. There's just no coverage. What we want to do is avoid a retroactive date on these coverages when at all possible. Sometimes you would need one, which would be like in the case of a company being bought and sold, the new company going forward wouldn't want to pick up the past wrongful acts of the prior owners or the prior management. So then you would want a retroactive date because you want a clean slate to go forward. But in general, if your company is the same as it was for the last 5 years and you're just moving along with similar management and similar ownership, you do not want to have a prior acts exclusion on your EPL. All of the policies will contain what we call a pending and prior litigation date. We call it a P&P date. And it doesn't necessarily just mean litigation. It means basically it's your knowledge. So if you move coverage from year to year, that date should stay the same because you have continuous coverage. But if somebody tries to say, oh, your last warranty statement was in 1998, but we just moved coverage, so we want you to re-warrant that you're not aware of any claims out there. That's when you want to push back because then you're losing continuity of coverage. You may not have any exclusions, but it could complicate matters if there was something out there that the insurance carrier could say you knew about and failed to disclose. So there's a difference between a retroactive date and a pending and prior date. Obviously, retro is worse. Pending and prior is still something that you need to keep track of. Claim, and this gets to the claims made part, claim is a defined term in the policy. And again, we said all these policies are different, but a lot of people consider a claim to be a lawsuit. And so they wouldn't report anything until they receive a lawsuit. And that will really trip you up in an employment practices policy. For example, if you receive a letter from the EEOC saying, you know, they've received an employee complaint and they're investigating it and they need you to respond, that we'll talk about, we'll look at the definition, but that is a claim under the policy. It doesn't need to be a lawsuit. So if you don't report it because you think it's bogus and you put it in your desk drawer, and then the next year you do get the lawsuit, they're going to deny coverage because you didn't report it. It was a claims made policy and that meets the definition of a claim. That trips up a lot of companies. So what we always advise is when anything even smells like a claim, report it to protect your rights under the policy. We call it a circumstance or we call it a potential claim. It's not like your auto coverage where your rates are going to go up as soon as the insurance company gets a report. It's just to protect your rights under the claims made duties. So as I said, all these policies are different, but this is a typical definition of a claim. Written demand for monetary damages or non-monetary relief. It doesn't have to be a lawsuit. It could be a written demand from that employee. It doesn't have to be on a legal letterhead. You can just say, I think you owe me, $50,000 for mental anguish, and that's a claim. So a civil proceeding, all of these things would trigger coverage. And like I said, when in doubt, report it. You get an EEOC letter, report it. This is fairly representative of what a definition of claim should look like. And again, sometimes these may never come to fruition, but lock it in on a claims made policy. So how do you lock it in? How do you protect your rights under the policy? Your reporting obligations are critical. As I said before, you actually kind of want to read these policies. I know a lot of people don't read their homeowners and they don't read their auto coverage, but this is something that's very important. It can make or break the situation. An example of the policy wording, it says it's your duty to report a claim, blah, 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 when some executive officer knows, or sometimes it says any insured person knows. And in this case, as soon as practicable, but no later than 60 days after the end of the policy period. That's pretty good wording, because some of these say, any insured has knowledge and within 30 days the claim has to be reported and before the end of the policy period. And so this could all vary, but you want the widest opportunity to report claims that you can get. And this is something that is negotiable. So look at the policy. If it says claims made must be reported within 30 days and can't report anything after the policy period, then call your agent and broker and say, hey, I need a little bit more of a window there. Or it shouldn't say any insured, it should say Director of Human Resources or whatever the case may be. So you do have some negotiation around this type of wording, but you have to know what it says. The other thing about your reporting obligations is if you don't report a claim and you start paying out of pocket to defend yourself on that claim, anything you pay prior to that insurance carrier's receipt of notice is not going to be credited to your deductible. It's not going to be acknowledged by the carrier. If they accept the claim after you've started defending yourself, they will start their reimbursement or their defense cost clock at the time of receipt of the claim. That's another really, really sticky situation that we get into when the insurers are thinking that they can dispose of something early and they start to defend, and then they end up, it blows up and they want to turn in the claim and the carrier's saying, no, you've prejudiced our defense for you, and we're not going to pay for what you paid for before, and we're going to deny the coverage because you tried to settle without talking to us. So again, I use the word pitfall several times because these policies are complex. So what about defense costs? There's two types. There's a hybrid version too, but basically there's a duty to defend style of policy, which is, I think it's better, especially for some of smaller insureds that don't have existing relationships with outside counsel with experience in employment related matters. So duty to defend is where the insured selects the counsel, they pre-negotiated rates, they have vetted the qualifications of these firms, and then when it's duty to defend, if they get a claim in for you and it has 10 counts in it and 8 of them are covered and 2 of them aren't covered, it doesn't matter. They're not going to allocate covered and uncovered. They're just going to defend the whole claim. That's them selecting counsel, them defending based on their counsel pre-approved rates, and they do not allocate covered and uncovered matters as long as something in the claim is covered. Now, reimbursement, on the other hand, is, let's say you insist you want to use your own corporate attorney, you have a relationship, they are qualified, then sometimes the carrier will say, okay, well, we'll put it on a reimbursement basis and we will pay you, you can choose the counsel. We're only gonna pay you what we would have paid, on various rate caps, but they're going to allocate covered and uncovered matters in that case. They're gonna say, we're gonna send us your bills and we're gonna line item, this is covered, this isn't covered, this is covered, this isn't covered. And typically the reimbursement comes in probably less than the full claim defense costs. But again, some, especially larger companies, feel very strongly that they want to have their own counsel involved in their cases. So that's a negotiation, and that negotiation should take place when you're negotiating your policy, not after a claim comes in, because oftentimes we have fights between our insured clients and our carriers that say, no, you can't tell us what counsel you have after the claim comes in. This should have been put on the policy when we were negotiating terms. So again, if that's something you feel strongly about, I would have those negotiations upon the anniversary of your policy negotiations. So what's a wrongful act? Again, these are all, these vary, but these are the typical wrongful acts that would trigger coverage under a policy. Clearly, discrimination, retaliation, sexual harassment, workplace harassment that is the hostile work environment, not related to gender or sex, wrongful termination, misrepresentation, defamation. And again, some of these policies have 20 other wrongful acts listed, and some just have words that say, or any other, kind of omnibus wording. The wrongful acts are based on obligations, regulations, and statutes that you're supposed to be complying with in the employment relationship. These are just the federal statutes that would trigger exposure for you should you breach your duties under them. Then when you add state regulations that all vary, and then sometimes even local regulations that you would potentially have to be in compliance with, it's no wonder that, a lot of you probably wear many hats in your organization, and some of you do not have designated HR specialists to keep up on all of this changing world that we live in. But it is huge, and especially if anybody has employees in like a state like California, where there's just reams and reams and reams of regulations that you need to comply with. So, a lot of areas that could present themselves as wrongful acts in the course of the employment relationship.
Hey, Lisa,
Yeah.
I have just one quick question for clarification before you move on. You talked about wrongful termination.
Mm-hmm.
How does that work in a state like Ohio is a right to work state, correct?
Yeah, the protection that you get under the right to work, and it doesn't, it's not the protection that you think you would have. If an employee files a claim and shows that whatever their allegations are, it's still a claim under the policy, and you still, maybe it would be disposed of down the line based on whatever your handbook says or what really happened. But in the case of whether it's a right to work state or not, they can still allege the determination was wrongful, and then the defense costs are accrued until it's adjudicated to be either, yeah, you didn't do anything wrong, and you don't owe that employee anything, but it still could cost money to get out of the suit. Does that answer your question?
It does. It does. Thank you.
Okay. So every insurance company, or every insurance policy has exclusions, right? I have a note here that says preamble is important. And what that means is the preamble to the exclusion could say, this policy will not cover claims for bodily injury, right? Because that's what your GL's policy is for. This policy will, or work comp. This policy will not cover claims for whatever. There's also what we call absolute exclusions, where it would say this policy will not cover any claim based upon, arising out of, or in any way connecting to or resulting from bodily injury. So in my, I'm looking at that saying I would much prefer the word for in front of my exclusion than I would based upon arising out of anything, because then the insurance carrier can like reserve their rights based on anything that they could, seem to be causally connected to the exclusion. So again, something to read in your policy. These are typical exclusions. Either they're excluded because it's not in the public interest to insure something, or it's better covered elsewhere. So criminal, fraudulent, or intentional acts, of course, it's not in the public interest to insure people for doing those types of things. But what you don't want to have is a policy that would bail on you if you're wrongfully accused of something like that, but you're innocent. So what we want is to see that they say, we're not going to cover you for this, this, or this, but we will defend you until it is determined that you are guilty of that. So that's the way we want the wording to speak. Intentional acts, I've seen some policies, and this is going back a few years, but they would just have an intentional act exclusion on the EPL policy without any caveats to that. And I'm like, well, anything you could, any sexual harassment is probably, even though you might not perceive it to be, it could be perceived by the recipient that you did it intentionally, and therefore the exclusion could be invoked. And so that is just too precarious for me. I would want some more words around when that exclusion would be invoked. So a couple of these are important. Americans with Disabilities Act. I talked about the example of the website accessibility being an ADA violation. So in your policy, there's coverage for defense for those allegations, but there wouldn't be coverage for compliance or remediation. So let's say somebody says you failed to accommodate them, they have a disability and they needed a wheelchair ramp and you refused to put it in. They sue you. Defense for that is there under the policy, but if you're found guilty of not accommodating them and you need to build a wheelchair ramp, the policy is not going to build your ramp for you. And that's kind of how these types of exclusions are work. Wage and hour claims are a lot of problem for almost everybody these days. There's, exempt versus non-exempt. There's a blur between gig employees and subcontractors and all this kind of litigation going on of who's an employee and who's exempt, who's non-exempt. It's just the coverage is not available for failure to pay overtime or rest breaks and class actions that will go back 10 years to say you didn't pay 1,000 people rest breaks for the last 10 years and now it's a class action. There's the coverage for that. It has all but dried up in the marketplace, and it usually, if you're gonna buy it, it's like a 7-figure deductible retention. Like you could buy $1 million in coverage and then have $1 million deductible. But what we do see, and it's starting to dry up a little as well, there's a small sublimit for defense costs that you could have in your policy if there's an allegation that a single plaintiff said, you classified me wrong and I should have been getting overtime for the last year. There's some defense costs that can be available for that, but it's going to be a small amount, and it's usually for a small number of employees. So if you have over 250 employees in your organization, there's not very many carriers that are going to even give you that small sublimit for defense costs there. Prior knowledge of potential claims, we talked about that being when you're negotiating coverage for the first time, you don't want to sweep anything under the rug because it could come back to haunt you and be declined. And then clearly claims reported to other insurers, because this is a claims-made policy. You can't report a claim under policy ABC and then report it again under the next year just because you want 2 sets of limits. Doesn't work that way. And then if you have your workforce is union or subject to collective bargaining, these policies are not supposed to be a backstop for the collective bargaining agreement. Other exclusions, fines, penalties, sanctions, taxes, these are all not in the public interest to ensure something that's meant to be a punishment. So, if you could just turn your punishment over to the insurer and say, pay my fine, then it wouldn't be much of a deterrent. So that's why they're excluded on the policy. So again, we talked about a number of pitfalls. We talked about no standardized wording or no standardized way to purchase the coverage. Talked about claims made. What is a claim, and how could you be tripped up by not reporting one? Know your obligations under the policy to make sure you're protecting your rights. Beware of a prior acts exclusion. I would hope that they're few and far between, but they do exist. And for versus based upon, that preamble that I talked about with the exclusions, you want to look for forwarding versus arising out of anything having to do with anything. And then defense costs. Not only will they erode the liability limit, but the manner in which the defense costs are interpreted by the carrier, whether it's duty to defend or reimbursement, all just nuances to consider when you're looking at these types of policies. So I have a couple claim examples just to see how these things can blow up. Hostile work environment. This is an interesting one because it's not even really in the work environment. This pilot claimed that he was being, subjected to some defamation on an online company bulletin board, and it didn't necessarily have to be during the workday or in the course of work. They denied responsibility, saying we can't control what happens outside the physical workspace. And the court decided that the employer was liable because the online form was setting related to the workplace. It wasn't in the workplace, it was related to the workplace. And they ended up paying $600,000 for a claim like that. So you can see things that you might even think that are not your responsibility or outside of your control can still come back to bite you. This is the world we live in. Wrongful termination. In this case, an executive of the company objected to the termination of another employee for filing a complaint about wage and hour. And then that chief operating officer was terminated. He felt in retaliation because he brought it up that, hey, that you can't retaliate against, you can't terminate an employee for filing a complaint. And he had, he made his thoughts known, and then they terminated him, and he settled for $500,000. Sexual harassment example. With MeToo these days, there's no shortage of examples. We could pick up a paper, on any street corner and read about somebody else who's misbehaved in the corporate world. This employee was taking or alleges inappropriate sexual comments, alluding a sexual relationship with another employee. And she asked her management to stop it. She reported the claim, and then they said that she was taken off key assignments and basically retaliated against for making the claim, and then filed a claim for retaliation and sexual harassment $550,000 later. Now, I want to point out that the last couple of claims, we're talking about retaliation as well as an actual wrongful act. Retaliation in and of itself is a wrongful act, and the creative plaintiff's attorneys, when they found out, when they can allege a particular part of retaliation in any claim, that the settlements are much easier to get. So that's been prevalent in the employment practices liability world for several years, that maybe an employee that you have has been problematic and is on a performance improvement plan. They know the writing's on the wall. They know that they have performance issues. They are creative too, and they can find a way to report something. And then once they are terminated, then they say, oh, I was terminated because I reported you about your waste disposal practices. So this happens all the time. It's something to be aware of. And once that retaliation card is played, it can get ugly. And again, more retaliation. Wrongful termination, breach of contract, retaliation, $120,000. Because she testified on behalf of another coworker who brought an action against the company. So it gets complicated. One of the things that I really want to drive home today is value-added services that should be, and most likely are, part of the policy that you're buying, and you may not even know you have access to. These are historically underutilized by all types and sizes of company, but in your policy, there should be a notice or a letter, a cover letter that says you are eligible with the purchase of this policy to have access to a litany of loss prevention services related to employment practices. The carriers want you to utilize this because they feel like you'll be a better risk if you do. But many people don't even register for it. It's just a matter of logging in and putting your policy number in, and then you get, there's a toll, again, these may differ, but in general, it's typically a toll-free hotline where you have 2 or 3 or 5 free hours with a legitimate employment related attorney that you can call and bounce things off of. There's checklists and compliance resources and sample policies and procedures so you don't have to recreate the wheel. There's online training for employees that you can document and will protect you in the situation where you get called up on the pan because the employee says, I was never trained in proper, sexual harassment or workplace harassment policies around here. And then you say, oh yeah, yes you are, because you took this training on this day, and I have it in my email log. So we have lots of resources that are free or reduced. You can get legal updates on a state-by-state basis, and some discounted additional services if your needs go beyond those types of things. If you need someone to come into your business and conduct diversity training or sexual harassment training or whatever, the carriers have pre-negotiated relationships, and you would get better access to and less expensive services as part of being a policyholder. So I thoroughly suggest you look into those services in your policy as well. So we're coming around to the end, and I wanted to talk about COVID as it's upending almost everything else we do these days. It's also seriously impacting claims and premiums and retentions in this world of employment practices liability. It's not only that you had to keep track of all these rules and regulations before COVID, it's that now we're dealing with furloughs and layoffs and return to work and employee safety and privacy issues, and all are just absolutely piling on. I had a situation where, it's not bad enough that you have to decide who you're furloughing and who's allowed to work at home and who you might bring back, but I had an issue where an employer wanted to start bringing people back, and this was before kind of the Memorial Day surge hit, but they wanted to start bringing people back, but they said, what, we have a couple of older individuals that are in that high risk category, so we don't really want to call them back first. Well, guess what? That's age discrimination. So you're damned if you do and damned if you don't in some of these situations where you have to have someone, you have to be able to consult an attorney on what your exposures are, and sometimes there's no good answer. But invasion of privacy, when you're asking, you know, them about where have they been and trying to contact trace and all the things that we could potentially be tripped up with, just really, really hard. And a lot of our employment practices carriers are starting to react by doubling your deductibles or your retention, obviously taking premium increases, and in some cases putting COVID-related exclusions on the policy, which we as brokers try to push back on, you know, hard. But we're starting to see it, and it's just part of the hard market that we're in right now. So speaking of the hard market, so in addition to the COVID, all of these, all of the MeToo and things that were happening in our world even before COVID were causing rates to go up 15 to 30%. Even without those situations. I mentioned California is really, really a problematic state to have operations in, onerous employment laws, and they keep pumping them out. So it's a tough jurisdiction. Other states are problematic as well. And, you know, again, there's been a lot of litigation, and there's, you know, things are, you know, in front of the Supreme Court talking about what is an employee. If I was an Uber driver 5 years ago, I wanted to be an Uber driver because I could make my own hours, I could work when I wanted to, and I could not answer the phone if I didn't want to. But now there's the litigation is saying, oh, no, you're an employee. And so now that means that I have to pay benefits, or Uber has to pay benefits to the employee as though they were under the direct supervision of, you know, as a traditional employee. So these lines are blurred, and it's causing a lot of litigation, and it's causing a lot of pricing to go up for this coverage. BIPA, if any of you haven't heard of BIPA, you probably should get educated on it. But basically, any kind of biometric information that you're collecting on your employees, if you don't get permission to do that and you use it, it's a violation of privacy. And Illinois especially is really, really bad with this, but it's catching on in other states too. And so a lot of underwriters are putting either sublimits or asking additional questions related to what type of information you're gathering from your employee base. It's becoming heavily underwritten. So these are all things that we're dealing with in 2020 and beyond. Clearly, the way the litigation is going, it does vary by state, but federal laws are getting tougher too. The Supreme Court just ruled to broaden the discrimination, sex discrimination, to include LGBTQ. That is something that we kind of anticipated was going to happen, but it's going to trip up some employers out there that don't have their policies down for in that kind of a situation, because it's very hard to control the workplace. You know, again, in the workplace, on social media, and in other potential areas where, you know, someone might allege that you knew or should have known that somebody was getting harassed. So the outlook for the coverage itself, and as I said, prices are going up, coverages are being restricted, but it's still something that that almost every business, I mean, if you have employees, you need this coverage, and you need to get the most out of the coverage. So that's all I have for prepared remarks. So if there are any questions, I'd be happy to take them.
Okay. Hi, Lisa. Yes. Okay. We do have some questions here.
Okay.
So, and if it's anything you already covered, I apologize. I'm trying to put them all together. Okay, so first, how are the riots impacting insurance claims? And if you're in an area that is having them occur, what can you do now to protect yourself?
Well, that's a big one. You know, that spans the scope to a much broader conversation, more than just employment-related practices. But if you, in general, the way that as a business owner, if you need to have employees come to your premises to do your job, when it might not be safe to do so based on social unrest in the neighborhood or whatever the case may be, that's typically not a trigger for employment practices. It would be more of a worker comp kind of thing. The employer can allege that they were subjected to an unsafe work environment, which is not an employment related, which is not a coverage trigger under this policy. But again, if we get to the point where some people have to go into work and some people don't, or some people feel like they're retaliated against because they don't feel safe to go into work and then they were terminated because of attendance, that's where that kind of a situation, that's where that social unrest can come back to haunt you from a lawsuit that this policy would react to. Hopefully that answers the question.
Okay, I think so. Here's another. Has the insurance industry taken a financial hit due to COVID?
Yes, absolutely, it has. And in the last couple of slides, we were talking about the claim tick up because of COVID. Now, there's typically a delay in when the claim is filed and when there's settlements, but there has been a lot of activity based on again, the furloughing, the business closures, the calling back, the privacy issues related to questions and how people are handling COVID. This is where, you know, from a legal standpoint, you know, there was changing guidance all over the place for the first several months. This is where that, you know, call the 1-800 hotline and ask the employment attorney what's the latest and greatest to be in compliance. And obviously it's a moving target. But so the carriers were seeing claims, and that's why, again, they're taking more rates, they're raising premiums, they're raising retentions, and some of them, again, have COVID exclusions, which is awful when you think about, of course, you know, everybody's struggling and there have been layoffs related to COVID. How you handle them, again, is, you know, you can't discriminate, and you have to not have adverse impact of who's going home, who's furloughed, who's terminated. Those are all regular exposures, but in light of COVID, they're amplified. And so legal counsel is very important. And that's the only thing I can say is there's so much to keep up on that's why you need to have the resources.
So what type of insurance would cover the COVID claims? Would it be this EPL?
If a COVID claim comes in and alleges a wrongful act that triggers a policy, so if the employee says, I was retaliated against by my employer because I didn't want to stand so close to somebody else and I felt unsafe and they terminated me for, you know, so they, you know, it's the allegation. So yes, absolutely, you can have COVID claims, not for bodily injury or not for if they get sick at work, but for how you're treating them in light of, again, let's say I furloughed A, B, C, D, E, and I didn't furlough F. Well, F, you know, everybody's like, well, why does Mr. F get to stay on the payroll and we were all furloughed? So there could be allegations of discrimination there. Like, okay, well, Mr. F, he's your favorite, and he happens to be a white male, and you terminated us people of color, or you furloughed us people of color, not because of COVID, but because of wrongful discrimination. So those things, they have to tie the claim in. COVID has to tie the claim in to the wrongful act under the policy, but certainly retaliation, discrimination, and terminations are up, allegation-wise.
Okay. All right. And then here's one. Is there insurance to cover litigation costs if an employee claims discrimination, even if all of their claims are subjective? Does that make sense?
Yes, again, we talk about the defense costs in these policies will kick in whether the claims are groundless, false, or fraudulent. They can think they've been discriminated against, and they can bring a claim against you. The defense triggers. You don't have to be, it doesn't have to be true.
Okay. All right. Just checking to make sure I didn't miss any here. Does anyone else have any questions that they want to put in? I think that's it. That was you covered a lot of great information and everything that was really relevant to things happening right now that business owners definitely needed. Yeah.
I hope it was a good use of time, and if anybody does want to talk about anything further related to this, I can certainly be reached via email. But I appreciate the opportunity to address you guys today.
Well, thank you very much for your time, and we really appreciate it. This was recorded, so I will be emailing it out to everyone later this afternoon. And yes, let us know if you have any questions to send Lisa's way. Thank you all for joining us this morning.
Thank you.